We have a wonderful packed morning for you. And to start us off, I'm going to introduce again someone you already know, President Travis of John Jay College, to begin our proceedings.
Thank you, Steve. So good morning, everyone. And we'll get a good night's sleep after last night's festivities. I tell you, that celebration we had last night of spectacular journalism, the awards that we gave to our colleagues from South Carolina and to Jennifer Gonnerman, and the talk by Maria Hinojosa was just elevating. It was just made you feel like good things can happen in the world, right? There are good folks doing good work, and it can make a difference. It was really great, and I congratulate Steve and the team at the Center of Media, Crime, and Justice for now 10 years doing this very important work. I'm here just for a short time to do something that is a great treat for me, and that's to introduce Ken Thompson. So let me just tell you why I think this is important for me personally, for John Jay, and for the audience here. So for me personally is sort of easy because Ken and I have known each other for a number of years. We've collaborated on a number of adventures having to do with criminal justice policy and having to do with the role of John Jay in the world. But this is also important for John Jay because this district attorney is a graduate of this college. So he's one of our alumni, very proud of him. And we know that there are many more who are following. Yeah, right there. Let's sing along here. E.T. There are many more following in his footsteps because he's been also a supporter of our Pre-Law Institute, which is graduating many students going off to law schools around the country with very strong financial packages, which is important these days. But let me put this in a bigger context. There is a new breed of DA in the country. John Chisholm is one. There are others I won't name, but the person you're about to hear from is one of them. So how would you characterize this new breed? They're people willing to take chances, people who do more than just count notches on the belt and conviction percentages as an indicator of success, who use words like legitimacy and procedural justice and even racial justice when talking about the work of a prosecutor, who are not afraid, as is particularly true in Mr. Thompson's case, to not only acknowledge that sometimes the system makes mistakes, but to do that in a very public and very visible way, and to set up entities like conviction integrity units that review old cases, as has been, if you follow this part of the news, this has been a sort of a really unfortunate saga in this county. But also individuals who are willing to take a closer look at the operations of the justice system, not as a system, but as the interaction between people and the law. And Ken is also my DA. I'm a Brooklynite, and so I am very proud to have him as representing my borough, but also really, really pleased to have him here today to be presented to this group of journalists from around the country because of that idea that there's a new breed of DA. So you're in for a treat, and we are really delighted that he's here and agreed to speak at this symposium. And I have to scoot out, but I'm really proud to introduce Ken Thompson. Have a great day, Jim. Thank you so much.
Good morning, everyone. I want to congratulate John Jay College for organizing this important event. And I want to also personally extend my thanks for being invited to take part in the second day of the Harry Frank Guggenheim Symposium. And as President Travis said, as someone who studied criminal justice here and got my college degree at John Jay, I am truly honored to come back and just say a few words to you this morning. This year's question posed by the symposium, race, justice, and community, can we all get along, certainly resonates in the wake of the deaths of Michael Brown in Ferguson, and Eric Gardner on Staten Island, and the executions of police officers Wei Jen Liu and Rafael Ramos in Brooklyn in December. The truth is that the question that's posed by the symposium today has never been more relevant, especially in the context of criminal justice. Because even today, we still struggle with the justice system's conscious and subconscious disparate treatment of whites and people of color as suspects, as defendants, as witnesses, and as victims. And we must do everything we can to deal with this perceived disparate treatment if we are ever to realize the community having faith in our criminal justice system. Now, race, and I know it's a topic that's been addressed and it will be addressed for the rest of this conference, experiences criminal justice in our country and also impacts the way a community views its criminal justice system and about whether justice is truly. Polls not only show that African Americans do not believe that our criminal justice system is fair, but polls also show that there's even a racial gap with regard to the perception itself. Now, what I mean by that specifically is that the Pew Research Center in 2013 did a survey, and out of the African Americans that they surveyed, that they polled, 70% of them believe that with respect to the police, that black people are treated less fairly than whites in their community. But yet only 37% of whites felt that blacks were treated unfairly. Now, with respect to the court system, 68% of the African Americans polled believe that African Americans were not treated fairly in our court system. But yet only 27% of whites held that view. And so, in short, there is a difference in the perception of fairness among the races, with African Americans holding a strong belief that our criminal justice system is unfair to them. Now, we all know, many of us know, that criminal laws are meant to protect us in our persons and in our property. But the legitimacy of those laws depend on society's confidence in a system that enforces it. Every segment of our society must have faith that police, prosecutors, judges, and defense attorneys will treat all defendants and all victims equally, regardless of race. They must have faith that that arrests are being made, that crimes are being prosecuted, that plea offices are being extended, and that sentences are being imposed fairly across the board, and that people are being given fair trials. And certainly that those who are convicted at trial are actually guilty of the crimes. Now, as Brooklyn District Attorney, I have a duty. I have a duty to do justice, not just to get a conviction. And that means I also have a duty to do all I can to reform and improve our administration of justice. If I fulfill those obligations, I believe that I will be able to help communities believe that their criminal justice system is fair. Now, this morning, I just want to talk to you about two initiatives in my office that I think exemplify my commitment to do justice, my commitment to improve the administration of justice. One is in regards to wrongful convictions. The other is with respect to how I have decided in Brooklyn to deal with low-level marijuana possession cases. First, wrongful convictions. We all know that wrongful convictions not only destroy the people who are wrongfully convicted, as well as their families, but they do great damage to the integrity of our criminal justice system. we cannot ignore wrongful convictions. Instead, what we have to do is we have to admit that our criminal justice system is not infallible, that we make mistakes in our criminal justice system, and that we make mistakes every day in it. Now, since we play a key role in the criminal justice system, prosecutors have a moral duty to lead the way in redressing these wrongs. Because if we do not safeguard the integrity of the criminal justice system, then innocent people will be wrongfully convicted, and the guilty will remain among us to continue to commit more crimes and to terrorize our communities. Now, upon taking office as Brooklyn DA last year, I inherited a staggering number of murder convictions that had to be reviewed. Most of them occurred more than 2 decades ago. Now, when many of these convictions occurred, New York City was a very different place. You see, last year in New York City, there were 328 murders. But in 1990, there were over 2,200 right here in this great city of ours. Many of you may recall that during the 1980s and 1990s, during the height of the crack cocaine epidemic, certain parts of Brooklyn looked almost like battlefields. And back then, Brooklyn alone had about 600 murders to deal with. You see, back then, there was a time when there were so many murders going on that the system was overwhelmed, and that prosecutors and judges and defense attorneys seemed to struggle with all the investigations, all the trials that were happening at the time. The system struggled. And so during that time frame of horrific crime rates, men in Brooklyn were arrested, put on trial, and convicted for murders that they did not commit. All you have to do is just look at this board over here of the men who I vacated convictions on. And I'm going to touch on that. That board reflects 12 men who were wrongfully convicted in Brooklyn. Now, I established my conviction review unit in Brooklyn to redress the enormous and irreversible damage being done to people who have been wrongfully convicted. And I've also created it to restore the community's faith in our criminal justice system. Now, when I became Brooklyn DA, I took the helm of the 3rd largest district attorney's office in the country in size, behind Los Angeles and Chicago. I have over 1,000 employees and over 500 prosecutors. But yet, when I began in January of 2014, only 2 of my prosecutors were reviewing wrongful conviction claims. And they weren't even given real resources. They weren't even sitting next to each other in the office. And so I thought that that was ridiculous. I thought that the people of Brooklyn expected more. And so I began to build a real conviction review unit. And I put one together that now has an annual budget of $1.1 million. It consists of 10 full-time ADAs, 3 permanent investigators, and other support staff. And what I have been so fortunate to have is the person who is in charge of the day-to-day operations is a prosecutor who's been in the office for more than 30 years. His name is Mark Hale. He's had over 200 trials. But I've also been very fortunate in that I was able to convince a very prominent law professor from Harvard Law School named Ronald Sullivan, who runs Harvard's Criminal Law Institute, to come down and serve as my special counsel to the Conviction Review Unit. Professor Sullivan spent many years as a public defender in Washington, D.C., and he also has served as an advisor to President Obama on criminal justice issues. Now, I not only put this unit together in Brooklyn, I also did something else to ensure the integrity of our investigations into these claims. I created an independent review panel of very respected lawyers who are in private practice, 3 of them. One of them is Bernie Nussbaum. And my independent review panel, they evaluate the cases that are presented to me by my conviction review unit. And they can ask for any evidence they want. They can direct us to do certain things. And they provide me with written recommendations as to whether a conviction should be vacated or not. But ultimately, I have the final decision as to whether to vacate or not. Now, my conviction review unit, what we do in particular is we embark upon very careful and thorough reviews of old cases. And we give priority to those cases that raise issues of actual innocence or due process violations. And what we do is we try to re-interview original witnesses. Now, that's sometimes not easy because these cases are so old and sometimes witnesses have died. Witnesses who testified at trial, case detectives, and quite often witnesses have moved on and moved to other places around the country. So what we do is we try to track down the witnesses, and we interview them no matter where they are. We've been to 12 different states so far as a conviction review unit, tracking down witnesses. We just came back from Georgia. We also go and we revisit the crime scene. And we comb through the case file to see if evidence was never presented or overlooked. And we also work very closely with defense attorneys and their investigators because the goal is to get to the truth. And so far we have reviewed 32 cases. And out of the 32 cases, we're standing by the conviction in the majority of those cases. There's absolutely no reason to disturb those convictions. But there have been 12 men who we've concluded were wrongfully convicted. And so I have moved in the interest of justice to vacate their convictions. The board that I alluded to earlier reflects those 12 men. Now, sadly, some of those men are no longer living. Some of them died before they were able to see the day when their names were cleared. 12 men, and we haven't even completed our work yet. We have in Brooklyn about 100 more murder convictions to review. Now, I know that later this morning a panel will discuss Sentinel event reviews and also whether our criminal justice system can learn from its mistakes. There can be little doubt that a wrongful conviction could be categorized as a Sentinel event. You see, in Brooklyn, my unit is focused on re-examining what went wrong and correcting any miscarriages of justice. But as our work progresses, we're also noting other factors that contributed to wrongful convictions to see if there's certain patterns that emerge. And so far, I can tell you that in several cases that we've moved to vacate on, we have found witnesses with substantial credibility issues. In particular, in 3 cases, the wrongful convictions rested heavily on the testimony of a woman named Teresa Gomez, who was a cracked-out, addicted prostitute who was used by a New York City detective, former New York City detective, named Louis Garcella. In cases, we have found upon closer review that this witness's credibility proved to be simply incredible. But yet, she was called repeatedly, and men were convicted based on her testimony. In addition, we have also started, in one case in particular, concluded that false confessions led to wrongful convictions. In particular, there were two young teenagers, David McCallum and Willie Stuckey, 16-year-old boys from Brooklyn, from the Bushwick section of Brooklyn, who were accused of going to Queens and abducting a man at gunpoint as he was getting out of his car in front of his house, and driving the man to Brooklyn, driving around with him for hours, and then taking him to a secluded area in Brooklyn and killing him, and then driving around their neighborhoods, two 16-year-old boys, for days in his car. The problem is no one saw those boys driving in the car once. The problem is no one could even prove that those two poor black boys could even drive. There was no physical evidence linking those two boys to the murder. There was no DNA evidence. There was no fingerprint evidence. There was no testimonial evidence. All there was to convict those two boys was perfunctory, contradictory videotape confessions. Well, we analyzed those confessions as well as the entirety of the case, and we concluded that those confessions were false, that they were based on false facts that the police fed those boys. In yet another case, there was a hotel receipt recovered from the defendant, Jonathan Fleming, at the time of his arrest for a murder that occurred in Brooklyn. But that receipt showed that Jonathan Fleming paid a hotel bill down in Disney World at the time of his murder, at the time of the murder. Now, Jonathan Fleming maintained that he was in Disney World with his children, and so he could not have been in Brooklyn in place to commit any murder. But he was put on trial, and the office fought him and fought his alibi defense tooth and nail. And we convicted Jonathan Fleming, and he was sentenced to 25 years in prison. 25 years later, Jonathan Fleming asked me to look at his case. His lawyers asked me to review his case. 25 years later, we discovered that receipt sitting in the file that was never turned over to his lawyer. And so the jurors at his trial never got to see that evidence. That crucial withheld evidence, I think, would have made a difference in Jonathan Fleming's conviction. And so I moved without hesitation. I had some of my detectives jump on planes and go upstate to New York, a prison upstate, and bring Jonathan Fleming down to Brooklyn. And we moved to vacate his conviction in the interest of justice. Now, in the wrongful conviction context, it is tempting to just point blame and just move on. But it's more important that we just don't point the finger of blame at the individuals who, through deliberate conduct, negligence, or honest mistake, played a role in a gross miscarriage of justice. We need to figure out the systemic issues that may have contributed to the egregious result. And we also have to analyze whether those contributing factors still exist or have in some way been adequately addressed over the patches of time. If they have not been addressed, then we, as prosecutors, as members of the criminal justice system, need to start thinking about how to make necessary systemic changes so we can reduce the chances of wrongful convictions in the future. Now, as Brooklyn District Attorney, I am determined to get to the truth in these wrongful conviction cases. And I know that that means that not everyone will be in accord, no matter what my decision is. But we must still do what is right. And sometimes that may mean vacating a conviction. Sometimes it may mean standing by a conviction. Both decisions are made in the interest of justice, because we cannot keep an innocent man in prison for a murder that he did not commit. Just like we cannot release a murderer back into the community simply because he claims that he is innocent. Now, in Brooklyn, we initially dealt only with murder convictions. And if you look at that board, 11 out of the 12 men up there were convicted of murder. But I've made a decision to go beyond murder convictions in Brooklyn and to look at convictions that don't involve the crime of homicide, convictions for gun possession, for burglaries, for other types of crimes. But my review of those cases, just like my review of the homicide cases, will be guided by the same principle, to make sure that justice was done. And one of the reasons why I know I have to go beyond murder convictions is the case of Michael Waite. Michael Waite is depicted on that board. He's in the bottom right-hand corner. Michael Waite is a man who came to this country as an immigrant from Barbados as a young man. He came to our country because of the great promise of America. Settled in Brooklyn with his family and got a job as a security guard at an apartment building in Brooklyn. And from all accounts, Mr. Waite was an honest, reliable employee, had no issues on the job. But one night he was in his security booth, and a woman came downstairs looking for her car, and it wasn't there. And so she accused him of stealing her car. He said, "I didn't steal your car." She said, "Well, you were standing right here. You must have stolen it, or you must know who stole it." He denied that it had anything to do with the theft of her car. He said he didn't even know which car was hers. He told his family what had happened, and his family said, "Mike, quit that job. We don't want any trouble." And guess what? He quit that job and found another job. And months later, the same woman who accused him of stealing her car accused him of burglarizing her apartment. You see, she said that she came home, she woke up one night and saw Mr. Waite in her living room holding her TV. And then he got startled and ran off with some other guys. There was very little evidence that there was a burglary in the first place. She recalled, or she maintained, that her apartment was in disarray. But when the police arrived, they didn't see any evidence of an apartment in disarray. There was no evidence to convict Michael Waite of this burglary other than the testimony of this one victim. He maintained his innocence, testified at trial in his own defense. So did his grandmother and everyone in his house who said he was sleeping that night that the burglary supposedly occurred. Well, he was convicted at trial and sentenced to 18 months in prison. Now, this happened in 1987, many years ago. He had never been arrested in this country before he was accused of this burglary. He had never been arrested since he got out of prison. And so Michael Waite has been living a life in Brooklyn, a law-abiding life. 4 children, a granddaughter. He's 54 years old now. And he went back to Barbados for one of his daughter's weddings. And when he came back and landed at JFK, he was stopped. He was grabbed by immigration officials because of his conviction many, many years ago for burglary. And that was in 2011. So for the last couple of years, the United States government has been seeking to deport Michael Waite, seeking to rip him apart from his family. He wrote me a letter a few months ago maintaining his innocence, saying that he had been framed and that he was facing not only was he wrongfully convicted. He was facing a wrongful deportation. And he wanted me to look into his case. And so we brought him in. We interviewed him. We pulled up his trial transcript. We found this man to be credible. But everyone who says that they're innocent is not speaking the gospel. So we had to track down the witness who testified against him. And she had moved out of state. She moved to a small town in Georgia called Covington, Georgia, outside of Atlanta. One of my prosecutors in the conviction review unit flew down to Atlanta with the trial transcripts in tow, rented a car and drove an hour from Atlanta to find this woman and asked her about her testimony. The woman denied ever testifying at a trial. So we had to bust out the transcripts and show her. The woman admitted that she had made it all up, that she was mad at Michael Waite because she thought he had stole her car years ago. And so she fabricated the charges against him, just like that. And so about a week ago, I moved to vacate Mr. Waite's conviction in the interest of justice. And I'm going to join his efforts to prevent being deported from this country and being separated from his family. If you think that wrongful convictions are just faces on a board, I want to give you one more example to show you why I feel so strongly about the need to do justice. I mentioned the case of the two young boys from Bushwick, David McCallum and Willie Stuckey, 16 years old and falsely accused of committing a carjacking and a murder almost 30 years ago. Well, Willie Stuckey, I couldn't get to him in time because, you see, he died while incarcerated at the age of 31 from a massive heart attack while maintaining his innocence. And so I called his mother to let her know who I was, because she had moved away, and to let her know that we were going to vacate her son Willie's conviction. And I told her that he should have never gone to prison in the first place. All I could hear on the other end of the phone was Willie Stuckey's mother crying uncontrollably. You see, she had lost her son twice, but she had never lost faith in him. And she told me that she never believed that her son committed that murder. And she corrected the record for me. She said he wasn't 16 when he was arrested. They grabbed my son when he was 15. Now, I asked Willie Stuckey's mother if she would come to court the next day when we were going to vacate his conviction and stand in his place. And she agreed to do so. So perhaps, in some small way, that helped the healing process begin for her. But no matter what actions are taken, once a conviction is overturned or vacated, the sad truth is we can't turn back the hands of time and erase what was done to people who were wrongfully convicted. We can't give them back their relatives who passed away while they were in prison. We can't give them back their children who grew up without them while they were in prison. But one of the things we can do is that we can do all we can to make sure that we not only free people who have been wrongfully convicted, but also do all we can to prevent wrongful convictions from occurring in the first place. I believe that we have in Brooklyn the largest conviction review unit in the country. I believe that we in Brooklyn will lead the country in terms of making sure that there is fundamental fairness with respect to wrongful conviction cases. But I want to also just briefly talk to you about the marijuana policy I implemented, because that also, I think, is grounded in my commitment to do justice. In 2013, the year before I became Brooklyn District Attorney, the Brooklyn DA's office prosecuted over 8,500 cases of low-level, nonviolent possession of marijuana. More than 2/3 of those cases ended up being dismissed by judges. I was deeply concerned that we were devoting our limited resources as an office and as the justice system in general to cases that were being dismissed when we should have been devoting those resources to more violent crimes like gun violence and sexual assaults and domestic violence. And so I decided to implement a new policy in Brooklyn regarding marijuana arrests, because I was also concerned about the fact that those arrested on marijuana charges who were disproportionately young men of color were unfairly becoming burdened and stigmatized by being involved with the criminal justice system. I mean, so many of these young men were being arrested, fingerprinted, and kept in holding cells, sometimes overnight, before being released. Now, some may say, well, many of those young men received adjournments and contemplations of dismissal, ACDs. The problem with that is, with an ACD, the case still remains open for a year, and it hampers a person's ability to get employment, to get housing, to get certain financial aid, or even to serve in the military. And so in July of 2014 in Brooklyn, I announced a new policy with respect to low-level marijuana cases. And that policy was simple. We declined to prosecute marijuana cases if the person who was arrested had never been arrested before, or who had a minimal criminal record. We declined to prosecute those cases. But if the person was found smoking marijuana, especially around children, especially in public places, then we would prosecute them. Or if they had a serious criminal record or open warrants. And then we had a carve-out for young folks. For 16 and 17-year-olds, we actually diverted them into a program and gave them social services to help them make better choices. Now, when that policy was in effect, we declined to prosecute about 1,000 marijuana cases. And when I instituted the policy, some people disagreed. But I have to say that the people of Brooklyn have been very supportive, because I think many join me being concerned with the fair and equitable administration of justice. Some reports maintain that almost 90% of the young men and women arrested in New York City for possessing small amounts of marijuana are young men and young women of color. But yet, I think we all would recognize that all types of groups use marijuana. Following the implementation of our marijuana policy back in the summer of last year, the city implemented its own new marijuana policy. In November, the city announced that it will no longer arrest people for possessing small amounts of marijuana. Instead, they will give them summonses. I think that the city's new marijuana policy is a step in the right direction. But there's a need for much improvement. And the reason why I say that is because of our overloaded summons court in New York City has a host of problems. And due process can be elusive there. Now, in answer to the symposium's question, can we all get along? I would like to say yes. But I also believe that to achieve that ideal, it's going to take a very conscious effort across all segments of society, in all spheres, not only in criminal justice, but in education, in health, in housing, in employment, and the list goes on and on. But if we are to fulfill the promise of a fair and just society, we must constantly review and assess our criminal laws and procedures and see how they impact different members of our community. Lastly, those of us who are entrusted, who have the honor of being entrusted with enforcing the law, must be ever vigilant that it is fairly and equitably applied. Only by these efforts can we expect the community to have trust and faith in our criminal justice system. Now, we don't have all the answers in Brooklyn, but I think that we have an approach that is designed to keep people safe, to protect public safety, but to also do justice. Thank you.
I want to thank the DA for being here. He's unfortunately not able to take any questions. He has to run to another meeting, so we will resume our programming in a second.
Could I just ask one question before you leave? What can you do to that detective now, and what can you do if that happens tomorrow to a detective who does it?
You have to keep in mind that the majority of the murder convictions that are reflected on this board occurred decades ago. David McCallum was in prison for almost 30 years. Jonathan Fleming was in prison for 25 years. There is an issue with these, we have not concluded, and we're still in the middle of these cases, we have not concluded that Detective Scarcella, that he did anything wrong. There's no clear evidence. There are many opinions. Some of the convictions that we're standing by involve Detective Scarcella, and there's no reason to disturb those convictions because the evidence of the defendant's guilt is overwhelming. But clearly, there were troubling aspects of what happened here in certain regards with this one witness, Teresa Gomez. And she's a woman who testified in about 6 different homicide trials. So there's an issue in terms of how old these cases are and in terms of a statute of limitations problem. But if we were to discover that a police officer today fabricated evidence, testified falsely, we would be able to prosecute them for perjury, filing a false instrument. There's a number of charges that we can bring. What I intend to do as the Brooklyn DA is to see us out of this mess and to make sure that we never get in a position again as an office where we have such a staggering number of wrongful conviction claims to review. And to make sure that we just don't look back, but that we look forward And so with Professor Sullivan's help, we are training my 500 prosecutors, especially the new prosecutors who are just joining my office. You see, I'm very fortunate in that people from all over the country, I've interviewed young folks graduating law school all over the country, and they all want to come to Brooklyn. They all want to live and work in Brooklyn, and I have an obligation to them to make sure that they understand that we have an obligation to turn over exculpatory evidence, that we can have trial by ambush. And so we are in the process of correcting miscarriages of justice. And I think everyone in my office knows that this is something that I feel very strongly about. Professor Sullivan's office is not in the basement. It's right down the hall from me, the Brooklyn DA. And I gathered all my chiefs together last year, and I told them, wrongful convictions must come to an end, and I will hold them accountable. I can't say much more about Detective Scarcella, but we are going to continue to look at all of these cases. The fact that I have 100 more murder cases to review is extraordinary. And now my decision to go into the non-homicide cases, how many cases do you think I have to review? I mean, we have 80,000 misdemeanor cases every year in Brooklyn. We have 100,000 cases a year. Now, I believe that the office has rightfully prosecuted and convicted many people, but I am not afraid to correct what I believe, what the evidence shows, is a miscarriage of justice. And so I want you to just follow the work that we're doing. I think is important. One of the things that we will probably do in a couple of months is to hold a wrongful conviction summit in Brooklyn, because this is something that I think the country needs to deal with, not just the folks in Brooklyn. Thank you all.